We are back on MorningLine. Thanks for joining us, talking legal issues with legal analyst Nick Leonardo, some of the high-profile cases going on. And we've had some good questions, a lot of them happening, and I know many of you follow them very, very closely. So if you want to join in the conversation about that or any aspect, perhaps, of this legal system and the way it works, and we'll touch on why there are so many delays and these cases are stretched on in a moment. But let's take a call from Cindy. Cindy, good morning. Hi, Cindy.
Morning, Dick.
Good morning.
Hi, Mr. Leonardo.
Hey, good morning.
Anyway, I was calling to say that he's absolutely correct. Your jurors that you pick are the most important things that you pick. Now, I got blamed for something I didn't do. And believe it or not, I kept saying, I want to bound this over to the grand jury. Well, Rutherford County didn't want to do that. See, they kept on and on and on for 2 years. And then I'd already been in front of the judge once. It was a 6-6 split. Nobody could agree, so it had to be retried.
Wow.
All right. So then the second time, and even the people say, just take the plea bargain. I said, no, I wasn't guilty, and I'm not taking the blame. I'm not guilty. I'll have to risk everything, but I'm going for it. All right, so I'm going in to pick my second round of jurors. And the judge says, I'm sick and tired of this. We've seen the video over and over and over. And Ms. Bromley didn't do anything wrong, and I'm throwing it out. So, you know, in that event, even though it takes over 2 years and you got to argue even with your own attorney, the thing you can do if you're innocent, stick to your guns and pick the right jurors.
Wow, she stuck to her guns. Now, that's easier said than done.
Oh, in retrospect, yes.
Yeah, in retrospect. And, you know, Cindy's a tough customer, and I see her doing that. But when we went to the break, you said you didn't think that there would be a plea deal in the Delkey case. Now, there's a lot of elements to that. Would Hambrick's family, not that it's their choice, but would they be in agreement with that? Probably not. They want to see justice for him. On the other hand, Delkey maybe feels I did nothing wrong, I want to move forward. But this guy's charged with first-degree murder. If he's convicted, he's looking at life in prison. If an offer were to come to him, and I'm not saying it would, but if it did, that maybe meant, well, you know, you'll do 10 to 15 with parole. Would you consider doing that? You could see why you might. He may firmly believe he did nothing wrong, but when you're looking at, well, even if I did nothing wrong, I could still be convicted by this jury and spend the rest of my life behind bars. Am I better to take this plea deal and maybe just spend, you know, maybe 7 years behind bars?
You know, that is a tough call. You know, and a lot of times that doesn't come up unless the state makes you an offer, right? You don't have any, if the state, in this case, in Delkey's case, makes no offer, well, then there's nothing to discuss. We're going to trial. But once that foreperson comes in and reads that verdict, if it's guilty, that's a mandatory bond revocation. You begin serving your life sentence that very moment. You'll step through that door and you will not be released ever.
And that plea deal is no longer on the table. You can't say, oh, I was convicted, I'll take that deal now. Doesn't work that way.
It's interesting to point out, though, that let's say there was an offer of 20 years on the table. You can take that plea deal if the prosecution is willing to continue to offer that to you up until the time the jury returns a verdict. So I've seen that happen. Not on, you know, I've seen it on DUIs, multiple offense DUIs, or something that, you know, after the proof comes out, based upon what the trial judge allowed into evidence, the parties met in the middle and thought, you know, maybe it's in the best interest of all of us to take a plea. But I think as a defense counsel, I think it's your duty to get the best plea offer that you possibly can for your client. And if they reject it, that's fine, but you want to send a letter or have them sign something saying they rejected that offer, because the numbers come back exceptionally high if you are found guilty.
Yeah, if the offer was still on the table, and I think everyone has to have a little bit of a sense that you can't predict a jury how the trial went for you. And, you know, when it's all wrapped up and the closings are done and they're deliberating and they're going into the second day, and maybe you've got a feeling that, I just didn't think that went well, or, you know, they did present a, maybe you go ahead and take it while they're deliberating. The thing is, have you ever seen a case where the defendant ends up saying, I'm going to take the deal, takes it, and then afterwards there's a poll done of the jury and they're like, yeah, we were going to acquit.
Well, and that happens. You know, as a trial lawyer, on both sides of the matter, your prosecution or state, one of the most fascinating things is to speak to the jury afterwards.
And they don't have to, but sometimes they agree to.
And you find out that you thought something that came out was just so significant. You thought it was the winning piece of evidence for you. It was so helpful. And then the jurors say, well, I didn't really put any weight on that. I didn't think too much of it, and here's why. And so it's fascinating. A lot of times, and especially in a case like this Delkey case, that, you know, it's kind of split. They they put together focus groups and little mock juries, and so they could go to say, an assisted living home or something like that and feed these people for the day and kind of conduct a mini trial, and then see what they think about their proof and how they could change that proof. Because I mean, there's nothing to keep you from doing that and getting a bite at the apple. Because again, you're wanting to know what these lay people think about your case and how they would decide, and they haven't been involved in it for the last 2 years.
How often does that happen?
I've done it a few times like that. Yes.
That's it. I never heard of that. That makes sense.
In the Delkey case, though, the hard part would be keeping it quiet from the media.
Yeah.
Okay, that would be the hard part. But it's a wonderful thing to do, and you do get some good feedback from people. And I say assisted living because they're kind of a captive audience.
Yeah,
and
they're willing. They have time, and
you pay them a little
people.
money and pay them lunch. Nothing expensive, but it's interesting to get feedback.
Wow. All right. Now, the other issues that a lot of people, aside from the insanity defense and all this, asked about are the delays. And, we had, earlier Paul asked about the Joe Clyde case. Well, many of you know that his father is charged with homicide, mother, reckless homicide, or not aggravated child neglect, the mother is charged with. Their trial's been postponed until next August. Not this coming August, but August of 2020. The delays, one after another. And here's my take on some of this. If I believe I'm innocent and did not kill my son, I'm not a happy clam sitting behind bars, which he is, for $1 million of bond, and so is she, for 2 years, my life getting wasted away. I want to go to trial, and I have a right to a quick and speedy trial. The only reason these delays occur is because the defense is allowing it or is asking for it. And I know it's not fair.
Or the prosecution may not have enough evidence. They don't really have anything.
Well, no, they probably don't. I think that's part of the equation. But couldn't Joseph Daniels' attorney say, look, he's already been in jail for a year. He's innocent. He demands that a trial come sooner than August of 2020. And that's reasonable. What's this whole thing about a quick and speedy trial? A defendant, you can't just lock up a defendant for years, when he's not guilty of anything and he's insisting he's innocent without giving him a shot at a trial in a reasonable time period. You can't do that. That's a constitutional issue. So I just wonder, if you're truly innocent, why are you willing to sit back for 2 years behind bars and be locked up?
Well, that's going to be a fact-specific determination. And of course, even if you were a defense attorney in that posture, your client's wanting you to go to trial, let's go to trial, and the prosecution says, look, we found this shoe. The only person who can test this shoe is in Timbuktu, America, and we have to mail it to them, and it's going to take a second. The lab is backed up. Judge, this particular witness is going to be on a family vacation then, or this particular witness is out of the country at that point in time. So they're trying to put it all together, and so, the judge is not, the state is entitled to a fair trial too, and we forget that, okay? Yeah. I mean, we're always worried about the defendant's rights and all of those things, and that's important, but the state is entitled to a fair trial too.
But I'm talking about reasonable. Everything you say is reasonable, and yes, meaning maybe have a trial within a year, but we've had the case with Gabby Doolin up in Kentucky. Horrible case where this little girl was raped and murdered. And the defendant's been behind bars since 2015. Now, the reason for that, a lot of reasons, chief among them, I think his attorneys have asked for delays. But he's been locked up for 4 years, claiming he's innocent. Now, if I'm innocent, I'm not happy being locked up for 4 years. But again, it's been his choice, asking for delay after delay. 4 years is absurd. None of these little excuses about, he's on vacation, our witness. If I'm a judge, that's crap. I'm not letting this guy sit behind bars for 4 years if he wants to trial. Sorry, get it together, guys. I mean, 4 years is, what I'm saying? Some delays are absurd.
Well, I mean, the criminal justice system in America is the best system in the world, but I'm not a fan or an advocate of the pace in which it travels, okay? It is very, very slow, and so when you hear the General Assembly talk about needing more funding, needing more judges, needing more courthouses, needing bigger jails, needing more court staff, well, that's a very real concern. I mean, just this past week, we had our state trial court judges appear before the Metro Council asking for funding, okay? Because the Metro does provide some of that funding. And so those are very real issues, and the system is backlogged. There's no doubt about that. I mean, we've got 6 criminal court judges here in Davidson County that are tasked with hearing all of these cases, and in divorce. We have 2 divorce court judges, and each one of them have about 3,500 cases, pending at all times. And so, we need more judges. We need more court staff, and I don't think it's really a bureaucracy. It's a real need. And when you get into these small counties, you have, like in Williamson County, you have 3 counties that comprise that judicial district. And so the judges, you have they would go from Perry County to Lewis County, and then to Williamson County. And so the fact that they're riding circuit, if you will, there's only so much of them to go around, like in the Holly Bobo case with Creed McKinley.
Yeah.
He hears all kinds of different cases in different counties, and so it's hard to get it together like that. And so there's a lot of talk about that in the legislature, but it's a real concern. And I think that if the citizens of Tennessee were to speak to the members of the General Assembly and say, hey, we want you to make a push for these kinds of things, we might see a change.
Yeah, they have to pay for it. That's crazy, that many divorces. But marriage, it's a sacred union.
Well, and in there, they're transitioning to a new way of life. So
if the average Joe knew how many people get divorced, don't talk to me about how it's some sacred union. For some, yes. For others, not so much. What'd you say, 3,200?
3,200, 3,300 pending.
In Davidson County alone.
But then we may have other judges in Davidson County that only have 300 cases. So again, it's something
they keep busy, that's for sure. Let's take a break. We'll be back with our final segment. More of your calls right after this.